And that love from coast to coast, man. Planting them seeds so you know we growing. Believing in us, damn right we know when. Ain't got time for the stress and pain. No time for hate, no time for games. It's time to take it up. Take it up. We gon' take it up. Hey.
Real talk for real life. Real talk for real life. Real talk for real life. Welcome everyone to Real Talk for Real Life. I am your host, Sherry Ann, and today we're diving into a topic that could change the future for you and your family. Joining us is the powerhouse herself, Alecia C Daniel Esq, an expert in trust, estate, and probate who knows exactly how to help you protect what matters. Get ready because we're talking wills, trust, advance directives, and why protecting what you love and who you love is one of the most powerful gifts you can give to your family members. Listen, before we get started, I got to tell you that Real Talk for Real Life is being presented to you all by Women of Dynamic Change, a 501c3 nonprofit. And our mission in short is to break down those barriers that keep women from being able to reach their full potential, whether it be mental, whether it be spiritual, whether it be physical. We're here to provide the support, the resources, the tools, and the education, and the networking and connections that help every woman to reach her full potential and become the best version of herself. I tell you, ladies, every Sunday that listen, all it takes is a mustard seed. That's it, a small amount of faith, and God is going to take you to places that you never could have imagined, right? And you are superheroes. Listen, God has given each and every one of us our own unique gifts. And once we understand how to utilize them, there's nothing that we won't be able to accomplish. And even more so when we connect with other powerful women and superhero women who know how to use their superhero powers, that combination, that relationship will be so explosive and dynamic to the point where it's going to help other women be able to live up to their full potential. And so I am so honored to have Miss Alecia C Daniel Esquire here today to share her knowledge and expertise with us on an important topic. This is August and it's Make a Will Month. And so we really wanted to explore and dive into the importance of planning for the what ifs, right? So, Miss Alecia Daniel, are you there with us?
I am here. Thank you so much for having me today.
Oh, no, thank you. Thank you. Believe me, this is a conversation that, as you know, I'm sure you know, that is avoided a lot of times, but we need to talk about it. And so, Alicia, let the world know about who you are and all the amazing things that you're doing for the society.
My name is Alecia C. Daniel. I am the owner of Genesis Law. We are a Florida-based estate planning and trust and probate law firm. Now, I am located in Port St. Lucie, Florida, but I do offer virtual services if you're not local to me. I cover the entire state of Florida. In addition to being licensed to practice law in Florida, I'm also licensed to practice in the states of New York and New Jersey. And estate planning, I've been doing this for almost 20 years now, practicing law. And when I first started practicing, estate planning and probate is what I was doing in New Jersey. My career ventured off into other areas of practice. And then in 2020, I had a moment of self-introspection. I think a lot of us did. And I decided I wanted to actually be more of the solution or helping my clients. And so I quit my job and I opened my law firm, and I only focus on estate planning, trust, and probate. And that's where I am today. In May of this year, I finished. It was a 2-year program. I went back to school 2 years ago.
I love it. Listen, and congratulations, go Canes. Congratulations on that accomplishment. Many people don't know what a will is. So can you give us a definition of what a will is and how it protects us?
I always say a will is the instruction manual for your probate. A lot of times people think that if you have a will, you avoid probate, and that's actually not true. What a will does is it identifies some key provisions. Who do you want to be in charge of your affairs after you pass away? In Florida, that person is called the personal representative. You're also going to name beneficiaries. Those are the individuals that are going to inherit whatever it is you're leaving behind after you pass away. If you have minor children, this is where you can identify the guardian. Your preferred guardian of those minor children would be named in your will. I always have to remind everyone, if the other biological parent is alive and willing, they get first dibs on that child. So you don't get to disinherit them. If their legal rights have not been terminated, they do have first dibs on raising the child. But what you are doing is letting the courts know, look, if that person is unavailable or they're unwilling, this is my preferred person. And that's important because if you don't provide that information to the courts, then it's going to be everyone else's opinion being provided to the court when the time comes. And so you asked me to talk about wills, but one thing about estate planning in general is it allows you to have a voice even when you cannot speak for yourself. So if you're incapacitated or you've passed on, you've got planning documents that will speak and tell everyone what your wishes are.
They say if it's not documented, how is anyone
Happen.
supposed to know, right, what your wishes are?
Right.
So one of the misconceptions, and Alecia, I hear often is, I'm too young to make a will, or I don't have enough assets, so I don't need a will. How can we break those myths of us saying, okay, well, we don't need to make a will because of this and because of that? What can we do to educate the public more so about the importance of getting it in writing?
Common misconception number one, I don't have enough property to have an estate plan or a will. Misconception number two, I am too young. Okay, once you are 18 years old, you are a legal adult. Okay. When you're talking about planning, we plan for incapacity as well as after we're gone. So the will is after we're gone, but there are some documents that we actually prepare that deal with what happens if tomorrow you become incapacitated and cannot manage your medical or your financial affairs. If you're 18, mommy, who has done everything for you up until now, cannot just go into the bank and just access your accounts, cannot pick up the phone and call, I don't know, anyone that you do business with and talk to them on your behalf, not without a power of attorney. And even more so, mom cannot go to the doctor or the hospital and make decisions about what's going to happen unless you have a healthcare surrogate designation. So we all know that tomorrow, you have no idea what's going to happen tomorrow, right? So we can all become ill tomorrow. And we can all pass away tomorrow. So 18 is your key point where you need to start making decisions and you need to document those decisions. And as far as assets, and I don't have enough, believe it or not, we all have something. And unless you leave a clear plan, a clear instruction manual about who you want to get that something, the state law is what's going to step in and make decisions. And so here's an example. I had a probate case. It was one of my most emotional probate cases. I had a gentleman, he was in his 20s, early 20s, and he passed away. Before he passed away, he had a lawsuit. So there was about $50,000 in a bank account of his. He was young. So what do young people do? They don't plan, right? And his mom raised him. His father was never in his life. He didn't have a will. We are now in a situation in probate where you don't have a will. The Florida statute just basically decides based on blood relationship who your legal heirs are. That father that had absolutely nothing to do with this child's life was now entitled to 50% of that bank account. And so this is a reason, tomorrow we can have a car accident and we can win money, right? You never know. So even though you don't think you have assets, you can end up having assets. And I've had probate cases where someone inherits after they've passed away. So what are we going to do with that money? What are we going to do with that property? If I don't have a will, we're going to Florida statutes, and someone that you probably would not have wanted to leave it to is going to get it. The only way to avoid that is having a plan in place.
So it needs to be documented, guys. That's the importance of getting that will and not putting it off for tomorrow. I think that's something that we do. We say, well, we have another day. And like you said, life is unexpected. And so we don't know if we have another day. So today is the day to take action. You talked about personal representative, and I've shared with the Real Talk for Real Life viewers that, I've gone through this process. And one of the things that I became was a personal representative, and it was mandated by the courts because unfortunately, my significant other who passed away, we didn't have a will because, again, that belief, we were too young. And we didn't want to visit that, right? Because the belief is if you talk about it, it's going to happen. But you know what? It's going to happen either way if you talk about it or not. So, how do we go about appointing a personal representative, someone to be responsible for whatever we leave behind?
So, the personal representative is going to be appointed in probate court, regardless of whether you have a will or not. So let's talk about a little bit about when probate is required before we talk about the PR part. And PR means personal representative. If you pass away and you own any property in your name, and that property doesn't transfer by operation of a contract or law, then we have to go to probate, where the court is going to allow us to determine who is going to receive that. An example of property that you'll have transfer by contract is like a life insurance policy. You name a beneficiary, and guess what? That's a contract. That insurance company is going to make the check payable to that person. Your retirement plans, you should have a beneficiary in your retirement plans. Example of property that passes by operation of law. Let's say you have two individuals that own real estate together, and it's joint with rights of survivorship. When the first one passes, the survivor automatically owns 100%. We don't need probate. So those are examples where probate's not going to happen. It's not going to be needed to transfer property from person who's passed away to the person who's the beneficiary or survivor. Now, let's say you have a bank account and it's only in your name and you don't have a beneficiary on that account. You pass away. Now we're in probate. The difference between having a will and not having a will is simply allowing whether your decisions and wishes are going to be carried out. Because if you have a will, you have told the court who your nominated personal representative is going to be. And if you don't have a will, Florida statute has a hierarchy of people. The spouse is going to be at the top, and then children and so forth. It goes down. And it's all about family, right? Because a statute, the whole purpose is we have to have a backup plan. And so they can't involve family dynamics, the spouse that you haven't really communicated with for 20 years. So they don't get into all of that. And all of that is not relevant when it comes to this world. So to have your choice of personal representative, you have to have a will. In the will, you name, anytime you're naming human beings, I always say name two. You need a backup. Primary personal representative, and you name your secondary, who would step in if the primary is not available or even unwilling to serve when the time comes. The will gets admitted to probate, so we take it to the courthouse. We actually deposit the original with the court, and as long as it's legally valid, we've served the right people who have a right to notice of the fact that we are intending to move forward with this will. As long as all of that's done and the judge looks at it and it complies with Florida law, the judge is going to enter an order that admits the will to probate and appoints the personal representative. And then what's next? A lot of people hear about letters of administration. It's not really a letter, it's actually an order. And the letter says, this person has been appointed as the personal representative of this estate. And it's pretty much your go-to pass. That's the document that you're going to have to give to everyone that shows that you're the one that they are allowed to speak with about this particular estate. Now, if you didn't have a will, the process is a little bit different for getting someone appointed. The difference is we're not filing a will with the court. Instead, we're filing a petition that shows the court who has priority per Florida statutes. And usually that's going to be the person who's also petitioning. And the same thing, as long as that person meets the qualifications to serve, then the court is going to enter simply an order appointing personal representative. And then they also sign the letters of administration. So that's where the PR gets appointed in the probate process. And that is step one of probate.
I have endured it all. And so, again, that's why it's so important for us to bring this topic to the forefront so that we can help avoid other individuals from having to experience difficulties, I would say. Right. I would say that because what, Alecia, I'm going to tell you this real talk is that it takes away from you actually being able to grieve the person who is no longer here. Let's talk a little bit about trust, because I heard that if you have a trust, and you can clarify it, that you don't have to go to probate. So how true is that?
It's true. So there are caveats, right? So what is a trust? Let's start there, because a lot of people hear it and don't don't really know what it means, but they think they need one and they think they want one. So a trust is actually a legal agreement where you are going to be creating rules and instructions for how any property you transfer into that trust is going to be handled. How is it going to be managed? Who is going to receive the benefits of that property when you pass away? Or even you can have it set up so that people can benefit while you're alive. You get to make that decision and you get to control it. When you create a trust, you're also going to name the trustee. That's the person who's in charge. Their job is to carry out your wishes as outlined in the agreement. If it is a living trust, or also known as a revocable trust, then you can actually serve as the trustee of that trust. And what you do is you're going to name you as the trustee for today, and then you're also going to name a successor trustee. And the successor trustee is going to be in charge when you become incapacitated and also when you pass away. And the reason why we want that built in is because we want to avoid having to go to the court. Because if there is a situation where there's no trustee, the only way, unless that document tells us how to get someone appointed, we have to go to court. Any property that is in your trust at death is not owned by you, technically. And so it transfers to whomever you've designated in that trust agreement without needing probate. That's how you get it there. Can we get property into your trust after you pass away if you didn't do it during your life? Yes, but we have to go through probate in order to do it. So what we do when we create a trust is we create what's called a pour over will. It's a last will and testament, but the purpose of this one is to transfer whatever's in your name individually at death into the trust. But the key with a trust, step one, create the trust, but just as important is to fund the trust. So I say, think of a trust as an empty box. When you create it, it's an empty box. It can only do what you want it to do if there's property in it. It can only control what is in the box. So you have to put property into the box. And again, any property in that box when you pass away, no probate needed. So that's how, I mean, a trust is a great tool to avoid probate. There are other ways. There's another key way here in Florida. If you don't mind, I'll just jump into that really quickly because they kind of go hand in hand. We have Ladybird deed. That's not the real name. It's really called an enhanced life estate deed. What a life estate deed. And that's life estate deeds are everywhere in every state in the country. Life estate deed allows you to own property during your life. And then when you pass away, that deed says specifically who gets that property when you die. So this is another way you can avoid probate. The difference between the traditional life estate deed that's allowed everywhere and the Ladybird deed that we have in Florida and a few other states is, and this is why I love it, when you have a traditional one, that person that you named as the remainder man, the person that's going to get it when you go, that individual has rights immediately as soon as you sign that deed under the traditional version. Under the Ladybird deed, they don't have their rights until you pass away. So what that means is you can change your mind. You can sell that property without needing that person to sign off. You can refinance. Now, refinancing is tricky because it's not every lender. Remember, lenders are in multiple states. And so they don't really like to see a Ladybird deed. So what oftentimes, if you're going to refinance, they're going to ask you to deed it out. So deed it back to yourself, do the refi, and then you can do your Ladybird deed after that. So you have to, back and forth. But that's because they're in multiple states and they don't really understand it, nor do they want to deal with it because it's unique to just a few states. But a Ladybird deed is a great way if you have real estate in Florida to avoid probate. And so that's why I said at the beginning, a lot of people think they need trusts. Not everyone needs a trust. Sometimes I have someone that comes to me wanting a trust, but then we delve into what their finances are because a trust is more expensive. And we delve into what their wishes are and who their beneficiaries are. And I can say to them, you know what? We can accomplish that for you for $350 instead of $3,000, right? So let's do that. And I'll walk you through the way to get the other things to avoid probate. And let's get you taken care of without having to go through a trust just because it costs, just because you heard that that's what you need.
That is something that is new for me. Alecia, thank you for that information. The Ladybird deed, that's something that I definitely want to look into myself because again, for someone like myself who's gone through I had to go through probate. You think, okay, trust is the best way for you not to ever have to go through that situation. And so knowing about the ladybird deed, that is great information. And so thank you for that. And then the cost difference, right, Alicia? That's a big
It's a
difference
big cost
between
difference.
350 and $3,000 for that, maybe that single mom or
Mhm.
who wants to leave her property behind for someone or someone who may not be able to afford that $3,000. So it is feasible.
Absolutely.
Right. It seems
Absolutely.
like it's feasible. And it's so, because a lot of times one of the myth is, well, I can't afford, right, to plan for my legacy, or I can't afford to plan or to prepare a will or probate. So now we have different options. So thank you for giving us that information. Listen, I want to talk about advanced directives as well. Advanced directives is something that, because by trade, I am a registered nurse, and so that is something that we talk about on the daily. And so, what exactly is advanced directives, and how does it protect us?
Okay, so we have something called a healthcare surrogate designation here in Florida. And what that does is you're going to be naming your surrogate, your person. That individual is going to be able to communicate with your physicians if you become incapacitated. They are going to be able to view and have access to your medical records so that they can make your medical decisions on your behalf. So, in order for them to make medical decisions, they need to have access to your medical records. They need to be the one that the physicians can talk to. But the key is you have said to everyone, this is my person. Because if you don't have that document, and heaven forbid you do become incapacitated, we have to go to guardianship court in order to have the court appoint someone. That costs money. And that also means people are going to come in with their opinions, right? When we have failures to create our plan, we have situations where someone that we would not have chosen could very well end up being the person that the court chooses. And so we avoid that with a simple document, a healthcare surrogate. Then we have the living will. What a living will does is it tells everyone how you feel about having your life prolonged by artificial means. So I always use the example of a persistent vegetative state. Would you want to stay like that? Yes or no? And if you don't have this document where you said no, guess what? Everyone's opinion is going to come into place. And a lot of people, I'm kind of aging myself, but it was a Florida case, Terry Schiavo. That was back in when I was in law school. So in '05 is when it happened. And, she was in her 30s. She was married, did not have she didn't have an estate plan at all, actually. And she had a cardiac event that left her in this state indefinitely.
Because she didn't have the advanced directives, it just caused, it sounds like it
Right.
was chaos and confusion.
The key argument in the case, in all the litigation, was what Terry would have wanted. And since she couldn't speak for herself, guess what? The judge had the husband's version of her wishes and the parents' version of her wishes. So if you have this document, we actually know what your wishes are.
How easy is it to set in place advanced directives?
What happens is, as far as my process, we have an estate planning consultation.
Okay.
During that consultation, I design your plan right then and there. Who are your people? Who would you want? Have you given any thought to who you would want to manage your medical affairs? And so I'm typing all that information down. Once I'm retained, I put it all together and create the documents. Honestly, I get it done within 48 hours. Sometimes I do it the same day. It just depends on what my schedule is. But and how difficult, the more intense of a plan, it's going to take a little bit longer. But the directives, that's probably the simplest. And so once you actually sign the document, it is official. Those are your individuals that have been designated by you in the event of you becoming ill.
Listen, our last and final question to you, Alicia, and we thank you so much for being here today, is if someone is ready and they've listened to this and they're like, you know what, I am ready to go ahead and start the process, where do they go? Who do they turn to, and how do they get it done?
Phone number is 772-539-9831. Just want to learn a little bit more. There are multiple ways to do that with me. Number one, social media. I am very, very heavy with social media. My handle across all platforms is Little Bit of Law. So it's LILBITOLAW. And you just type that in Google and you'll find me everywhere. And then also on the second Saturday of every month, I host a free Wealth, Wills, and Trust webinar where I delve into a little bit more of the conversation about what these documents are and how we can avoid probate and how we can make sure we have every place. And so I actually run ads where you can click on the link to sign up for the next webinar, but it's also on my website. You would go to the genesislawpa.com, and at the top where it says resources, you click on that drop down, and then you would be able to register for the Wealth, Wills, and Trust webinar. And again, it's free. I host it on the second Saturday of every month. It's from 11 to 12. There is a at the end. So if you have questions about what I discuss, we don't talk about individuals and their situations because it's not a consultation, it's a public forum.
Thank you so much. And listen, this is an invitation for you to come back in the future because what information you've given today is so, so very valuable. And again, Alecia, this is a topic that we try to avoid, but we really need to talk about. And so I thank you for being here today on Real Talk for Real Life. Listen, sis, if you have been waiting to get your affairs in order, this is the time, not tomorrow, because tomorrow is not promised to anyone. And so let's make it to the point where we're building our legacy and we're preparing so that our family members don't have to struggle. They don't have to be in confusion as to what our wishes are. Let's put it in writing. Let's put it in writing. A huge thank you, thank you, thank you to Miss Alecia C Daniel Esq for breaking it all down for us and making it simple for us to understand and take action with confidence, guys. And a special thanks to Daniel Wagner, the attorney, for being a part of this dynamic connection. So thank you. Ladies, don't just think about it. Again, like I said, tomorrow's not promised. Things can change at a drop of a dime. And so let's go ahead. Let's put it in writing. Let's get our wishes put in writing so that our family members will know what to do when we're no longer here. And as I say, when you love something, guess what you do? You protect it, right? This is Sherry and this has been an amazing conversation. And I always say if it has touched at least one person, then the mission has been accomplished. Until next time, ladies, keep living, loving, and protecting what matters most. Thank you, Miss Alecia Daniels.
Yeah.
Take care and have a great day, guys. Thank you for joining. Bye-bye now.